Welcome back. Now, in a landmark judgment, the Supreme Court has held that mere storage of a child pornographic material is an offence under the Protection of Children from Sexual Offences Act. Now, the top court has set aside the Madras High Court's order that said that mere downloading and watching child pornography is not an offence, calling it an egregious error in passing the judgment. Now, this judgment also restores the criminal proceedings against a man charged with downloading child pornographic content, where proceedings had earlier been quashed by the Madras High Court. Now, the centre has been asked to bring in an amendment to replace the word child pornography with child sexually abusive and exploitative material. Courts have also been asked not to use the word child pornography going forward. And to take this discussion further, let me go across to my colleague Harish, who's joining me right now. Harish, very, very clear terms over there by the top court. They are not mincing their words. They're calling it to be a case of offence, even if it's mere watching or storage. But they are also saying that the government of the day must try and amend the term child pornography itself, and has also cautioned the courts against the usage of the term child porn. They want it to be termed as child abusive and exploitative material. Take us through what exactly happened as far as this landmark judgment is concerned.
Yes, the Supreme Court has said henceforth the courts must not use the word child porn. In fact, the child pornography, saying it's a very limited and narrow usage because it involves a lot of exploitation of young children, even toddlers, and said that henceforth it should be child sexually abusive and exploitative material. In fact, so widening the ambit and ensure that such kind of exploitation is better dealt with. So the Parliament has been asked to make an amendment in the POCSO Act in this regard, and courts also asked to refrain from using the narrow word like child pornography. The biggest takeaway is that the Supreme Court has struck down the Madras High Court judgment, which had said that merely downloading and watching child pornography is not an offence under the POCSO or the Information Technology Act, and has said that yes, it is an offence just like creating, publishing, disseminating, transmitting, especially for financial gain and other benefits, which makes it an all the more graver offence. So this is what the Supreme Court said, also noting that use of children for making porn is a very, very grave offence and has to be seen like that by the all the courts in the country. So the Supreme Court, in a way, cracking down on child pornography, making of such videos, and also very significantly emphasizing on the need for sex education in schools, and saying that at present in today's society, social stigma is resulting in schools not providing sex education to children, and also the children and the parents attach too much biological activity into such education, and there is a social stigma. So that has to be done away with, and Supreme Court bench has emphasized on sexual education in schools. So in many ways, it's a landmark judgment. Remember, the Madras High Court's judgment has been called as in fact, been criticized by the Supreme Court, which said that this downloading and viewing of child pornography is also an offence, and this issue was brought to the fore by several child rights activists, child rights NGOs who felt aggrieved by the Madras High Court.
Absolutely. And now let me take this question across to our esteemed panel of guests. Harish, I thank you for joining us with all those details about what exactly transpired in the courts today. But like my colleague Harish was mentioning, that there is an emphasis on the need for carrying out age-specific sex education. That was one of the reasons where the court has underlined that it's imperative that the government has a program whereby which there is a need to carry out age-specific sex education. And to discuss this further, I'm joined by esteemed panel of guests this afternoon, Amol Sinha, who's the Additional Standing Counsel, and also I'm joined by Meenu Parda, who is the lawyer and child rights activist. Good afternoon to both of you. My first question would go across to you, Ms. Meenu Parda. You've heard what exactly my colleague Harish was telling us about the court's verdict today. a landmark judgment over there. Watching and storage has been termed as an offence under POCSO. But do you think that this is too late in the day? This was long time coming. Why did it come to a situation like this where the Madras High Court order had to be put aside by the Supreme Court and then this concern was being addressed? Do you think, Ms. Meenu Para, that the government should have woken up to the need to try and ban child pornography at the very outset?
Yes, thank you, Samya. I hope I am audible. So this judgment is absolutely very concerning, issued by the Madras High Court, and I fully support the Honorable Supreme Court recommendation to Parliament to redefine this term child pornography as a child sexually abused and exploitative material. This accurately reflects the harm and trauma which can be inflicted on children, which goes beyond mere pornography. And what is more important, that Supreme Court has rightly pointed out that to establish an offence under Section 15, Clause 3 of the Protection of Children from Sexual Offences Act, it must be proven that storing such material was for personal gain. However, I believe that our laws need to go beyond this requirement, because merely storing or viewing child sexual abuse material should also be seen as a participation in child exploitation and must be penalized. The Madras High Court ruling that merely watching child sexual abuse material isn't an offense is actually deeply concerning. Watching such material perpetuates the demand for it. And by allowing this loophole, we are giving people a way to passively engage in child exploitation indirectly. Thankfully to the Honorable Supreme Court of India, who has intervened and reinstating the criminal proceedings and showing that such action cannot be overlooked. This sent a powerful message to the whole society that any engagement with child abuse material is a crime. And the act of watching this material may seem passive, it is not active, but it directly fuels the abuse. Every time someone views this content, it supports a cycle of exploitation. The children depicted are the real victims, suffering unimaginable trauma. By making viewing illegal, we can cut off the demand that drives this horrific industry. These children are left with lifelong scars, lifelong trauma. When we talk about the child sexual abuse material, we must remember that every image or every video represents a moment of exploitation and trauma that never fades for any children. So it is a high time that we strengthen our law to close these gaps.
Absolutely,
And
Ms. Para.
Section
Let me clear the
67
question across to Amol Singh, who's the additional standing counsel of the Delhi Police, also joining us right now. And I'll come back to you, Ms. Para, for you to complete that point. Mr. Sinha, you've heard what Ms. Para was saying, that there is a need to try and even look at those who participate in trying and creating or indulging or even encouraging the child sexually abusive and exploitative content. There should be a law whereby which all those who even remotely are associated with child pornography should be booked.
I think that this decision of the Honorable Supreme Court is a decision in the right direction. If you look at the decision, it quite clearly points out as to why the term child pornography has been now dissuaded with, and the courts have now been directed not to use that term. There's a reasoning given in the judgment itself, and also the judgment looks at the various aspects which are involved with the issue of child pornography. It looks at, the judgment itself looks at the aspect of the victim itself, and the fact that the child victim is the child pornography is so heinous. The reason being that it doesn't end with the act itself, but it continues maybe years thereafter, where this video clip or through the IT media, whatever means there are, that he continues to be exploited. So therefore, this decision is in the right spirit, and the directions given by the Honorable Supreme Court to the Parliament to enact the changes are to be welcomed. As and when the Parliament passes a law, it would, I'm sure it will take into account these suggestions of the Honorable Supreme Court. But in the interregnum, the Supreme Court has tried to plug the loopholes which had existed with the issues which were addressed by the Honorable Supreme Court in this decision.
Mrs. Sinha, the court has also urged upon the Parliament to try and revisit and amend the terminology child pornography, and also POCSO itself, that how POCSO should try and include child pornography or child sexually abusive content under its remit. Could you take us through the finer lines that has been spoken about it, and should this not have been done earlier? Of course, the parliamentarians are now going to be taking it up, but why was this concern not addressed earlier?
You see, if you look at the term which is used by the Honorable Supreme Court in terms of para 226 of the judgment, that talks about why the term child pornography is now being disassociated, or the reason is that the term leads to trivialization of the crime, and it is often seen as a consensual act between the two adults, whereas in this case, when a child is being abused and through it's being recorded and disseminated, there is no consent. So therefore, that is the reasoning adopted by the Supreme Court when it says that from henceforth no court will use the terminology of child pornography in its decisions and judgments. So I think it recognizes the latest positions and trends available across the globe in terms of dissuading the term of the use child pornography with the term which is CSIM, which is child sexually exploitative and abusive material. So I think it recognizes, it places us in line with the latest jurisprudence which is available across the globe, and in my opinion, this judgment has to be welcomed.
Of course, it's a welcome judgment, and we are waiting to see as and when the parliament reconvenes and the lawmakers are going to revisit the terminology child pornography and also bring about amendment as far as POCSO is concerned. We shall wrap this conversation over here. Thank you, Amol Sinha and Ms. Para, for taking your time and joining us over here at Mirror Now.
Thank you.